This is the case of Saudi Arabia v. Nelson. Who were the key parties involved? This case involves the individual Scott Nelson, an American foreign citizen, who filed a personal injury suit against Saudi Arabia, a sovereign government. Nelson was recruited in the United States to work in Saudi Arabia as a monitoring systems engineer at a hospital. While employed in Saudi Arabia, Nelson discovered safety defects in the hospital's oxygen and nitrous oxide lines. After this discovery, he reported his findings several times to hospital officials and was continuously told to ignore such issues. He also reported the problem in the oxygen lines to a Saudi government commission.
Several months later, he was called into the hospital security office, arrested, and transported to a jail cell where he was shackled, tortured, beaten, and kept without food for 4 days. Nelson was released after 39 days and was allowed to return to the United States. This is where he filed the suit seeking damages for personal injury due to the abuse and torture he suffered under arrest. Further, Nelson contends that Saudi Arabia should have alerted him to the hidden dangers associated with his employment and therefore claims a basis of recovery on Saudi's failure to warn him of such harms.
What is the relevant context or legal mechanisms related to this issue? This case was ultimately heard at the Supreme Court of the United States of America, as the decision in favor of the plaintiff at the U.S. Court of Appeals was appealed by Saudi Arabia. The Foreign Sovereign Immunities Act is a relevant legal mechanism to this case. This act of 1976 says that foreign states are entitled to immunity from the jurisdiction of courts in the United States, unless the action is commercial activity done by private actors within the market.
A state engages in commercial activity under the restrictive theory where it exercises only those powers that can also be employed by private citizens, which is distinct from those powers peculiar to sovereigns. What are the arguments put forward on each side? Saudi Arabia relied upon the Foreign Sovereign Immunities Act to argue that they were immune from the subject matter jurisdiction of the federal courts of the United States of America. Simply, the plaintiff cannot win the suit filed against them because the United States has no authority to determine the validity of the Saudi government's decisions. This is because the Nelson's personal injury suit does not fall under the commercial activity as it is defined within the Foreign Sovereign Immunities Act.
However, Nelson contends that the defendant, Saudi Arabia, was not immune to prosecution under the Foreign Sovereign Immunities Act. This was because the list of exceptions refers to the state's conduct only. A state is denied immunity if its conduct is private and not public. The plaintiff asserted that job recruitment, contract of employment, and employment itself constituted the commercial activity that led to and associates the wrongful injury claim with the Saudi government's commercial activity. Basically, Nelson contends that the process of recruiting, hiring, and subsequent employment led to or indirectly associated with his torturous injuries. It must be decided whether foreign states performing public and not private conduct are entitled to immunity from the jurisdiction of the courts in the United States.
What are the cases in support of each side? In concurrence with Saudi Arabia, Justice White argues that both the hospital's employment practices and its disciplinary procedures have no connection to the U.S. as a country. Without such a connection, the Act does not grant the Nelsons access to American courts based on their suit. In comparison, Justice Stevens argues that if the same activities had been performed by a private business, jurisdiction would be upheld. Justice Kennedy further elaborates upon the argument brought forth by Stevens. He states that the claims alleging that the hospital and the government were negligent as they failed during their recruitment to warn Nelson about the foreseeable dangers based upon commercial activity has substantial contact with the United States.
Simply, Saudi Arabia is within the commercial activity exception and the jurisdiction of the federal courts of America. The failure to warn counts does not complain of a police beating in Saudi Arabia. Rather, they complain of a negligent omission made during the recruiting of a hospital employee in the United States. The Nelsons have proved that the hospital's recruiting agent did not tell Nelson about the foreseeable hazard of his prospective employment in Saudi Arabia. What was the resolution of the case and its implications? In response to the question, it must be decided whether foreign states performing public and not private conduct are entitled to immunity from the jurisdiction of the courts of the U.S. The Supreme Court of the United States majority upheld, Yes, foreign states are entitled to immunity from the jurisdiction of courts in the United States, unless the action is based upon a commercial activity in the manner of a private player within the market.
They found that Saudi Arabia's torturous activity does not fall under commercial activity within the meaning of the Foreign Sovereign Immunities Act, and therefore could not be tried under the courts of the United States. The state's conduct boils down to abuse of power of its policy by the Saudi government. Further, Nelson's failure to warn claim must also fail, as sovereign nations have no duty to warn of their inclination for torturous conduct. Simply, the Nelson's action is not based upon a commercial activity as defined within the meaning of the Foreign Sovereign Immunities Act and cannot be tried by American courts.
The decision was made in favor of Saudi Arabia. The implication of this case is that American citizens who travel abroad to obtain meaningful employment cannot hold of a sovereign nation accountable for bodily injuries they may face under the Foreign Sovereign Immunities Act. This means that it is safer to work within the United States border than to work elsewhere, unless employed by a private actor or conducting a commercial activity.